So who in here thinks that they've got something that's potentially patentable? Give us some quick words. What do you got?
Me and my dad made a leaf burrito, so instead of putting leaves into like the small brown paper bags, it's a tarp that's stapled on the sides and that you can fold over so you can fit a lot more leaves in it.
Mhm.
So then when you go to the dump, it's just more of a 30-second thing than taking out the bags. And if you want to reuse those, you have to like dump them or back in the car.
Yep.
I got a particular type of pool cover, above ground pool cover.
Okay.
All different sized pools help keep water and leaves off, rather than, because I've learned this from having my own pool, it takes sometimes two people to get your cover on over the bubble and all that and clean all the leaves and water up. So I came up with an idea in my head on how you can install it yourself very quickly with just an air pump, like a Coleman air pump, if you will. Shed water, leaves, and snow off your pool, and all you gotta do is deflate it in the spring.
Okay. What do you got?
I invented a bar of soap that creates an exothermic reaction with cold water. Heats up.
It's a chemical reaction of some kind. Is it natural? or-
Process, natural, yeah.
Great. I've heard you say that before, so
I
it's
won
good
the
to see you
Maker's
again.
Pitch. Yeah, Maker's Pitch for the Entrepreneurship for All.
Yep, okay, great. Okay, so this is a really small group, so I would encourage, if you guys want to move forward a little bit, you know, I'm not going to give the uber formal presentation here or anything like that, so just stop me if you guys have questions. You know, I kind of put some general themes about patents on these slides, but if I dive too deep too quickly and you guys are bored, say something, because patent law can be really, really dry. So I tried to just keep this really high level, but if it's too high level and you want to know more specifics, we can work on that too. Okay? So, do I have an invention I can patent is kind of what a lot of you, I think, are thinking. And so, the question for you is, okay, you know, where do I start? Do I talk to a patent lawyer? Do I do some of my own due diligence ahead of time? Heck, I don't even know what kind of a patent I should be going for. You know, it's kind of a scary legalese kind of concept, if you will. I would actually press you to initially think about your invention and think about its applications, who and how you could sell to a market, if there is a broad commercial market, and that will help you to determine if it's something that's worth patenting. So you have, it's not just the novelness of the technology, it's its application that will help you determine if it's worth spending the kind of money that you're gonna need to spend in order to not just submit a patent application, but successfully prosecute and defend those claims that you're gonna develop, which can be expensive if you think the entire world is your oyster and you're gonna sell into the entire world, and you're willing to take the time to do that. You know, a patent application gets filed, and as you'll see in some of my slides, it's not 3 weeks later you figure out if you've got a patent or not. It's a little bit longer of a process. So this is not for the faint of heart to be like, oh yeah, sure, I'll just submit this weekend, and you know, it's a long weekend, I've got till Monday, and I can submit this through an online process. I would recommend, if you're gonna go through this process, be diligent about where you start and what kind of due diligence you do on your own technology before you embark on retaining a lawyer to help you develop a patent application, okay? So field of use is something to consider. Who's the existing competition? That doesn't just mean who has my exact technology idea, but what is the current solution currently in practice? What, are there other emerging solutions that may circumvent what my technology is and make it irrelevant by the time I get a patent application, or by the time I get a patent awarded, okay? And self-evaluation of prior art. Who knows what prior art is? Take a guess.
Inventions that are obviously similar, out on the.
That's correct. Anything, prior art is anything that's filed or pending okay? So anything that's been issued, a patent that's been issued, a patent that's been filed and hasn't been issued, that's all considered prior art. I hate to break it to you, but you should never consider that you are the only guy thinking about this problem, okay? Only guy or woman thinking about this problem. There are a lot of other people who are working in similar areas, and chances are somebody before you has written the broadest claims in a patent that they can think of, that although field of use, okay, where you're gonna apply that technology may be different, they may have encompassed it in a really broad claim in a previous patent application. So, is everyone comfortable with field of use as a concept? So, you know, they may have written a claim and they may have said it's gonna be for medical applications, but they may have written it in such a way that it covers, I don't know, everything that's a plastic material that biodegrades at, you know, 96 degrees over 12 days or something like that. And so you may have a different application for that, and they may be using it in a different field, but their patent still covers a much broader range. Okay? So, so how do you do that? Novelty is the key here. All right, can you think about your technology, how you make that technology, what the technology is, what the individual components of your technology are, and determine what is not obvious about your technology, okay? Novelty is a big issue for getting a patent issued. You guys are already glazing over. Are there questions in that terminology? Or questions generally? So a good place to start is the Google patent. Okay, you can literally go up online and we'll do an example. We'll probably pick your example. And you can put in keywords. So this is a very effective way to start doing your level of due diligence on what's already out there and what may already be commercialized. And I would recommend be creative, okay? So you need to think about the technology itself, the chemistry itself, how you make that. That's a process. It could be unique or it could be obvious. If it's obvious, you're not going to put that into your patent, okay? The United States Patent and Trademark Office is also a great resource, and you can do searching there. So I recommend, you saw how non-spec says they did 5 separate searches with lots of different people. These were all people who had expertise, or at least had some base knowledge of the technology that they were all working on, and they all did separate keyword searches on Google Patent and U.S. Patent and Trademark Office. And then literally what happens is you develop a mega list, frankly, of every patent issued or pending that's been published that may apply. And unfortunately, your job is to go through and read each of those patents and those patent claims and compare it to what you know about your technology. So if you find something and you go, wow, this is exactly the same, you don't have that as part of your patent. And so what you do by doing that is you boil down to what you believe is quintessentially the most novel thing about your technology at the end of the day. And if it's not broad enough, it may not be worth patenting. Okay, so just keep that in mind. If you get down to evaluating what's already out there and you determine, okay, I've got 1 or maybe 2 things that are very narrow but novel, it may not be worth patenting, actually. It may just be worth moving forward with the trade secret. Okay. How many of you guys are thinking about a startup based on your technology? 1.
Thinking of what, a startup what?
A startup, you're thinking of doing a startup with the technology that we're talking about today, or the technology that you're focused on today. No? So we have 1. So Steve Teller just walked in, and he's the brainchild of Difference Makers here. And just so you guys know, both he and I actually sit on the leadership board of E4All as well. So
And we have a meeting Thursday morning.
we have a big
8 a.m.
meeting
Big
Thursday
like
morning to
meetings,
talk
yeah.
about the next incubator group coming in. So have you, who's here from EFROL? Oh, wow, there's a lot of you. So how many of you are applying for the accelerator? And how have you found the experience so far? Pretty good?
I really like it.
Okay. Well, you know, you got 2 leadership committee people, so if something's not working, you have the responsibility to tell us what is or isn't working. But we love EFROL. We love for David and Leanna and everybody. So, and they regularly will have patent attorneys, frankly, come in, just so you know. As does Difference Makers. They'll do office hours. They'll answer, you know, key questions, particularly if you've already done some of this prior art type activity. You can ask specific questions. Get as much of your attorney's advice for free if you can, because it starts to get pretty expensive. The guys who specialize in IP don't charge $50 an hour, so just keep that in mind. You probably have that experience firsthand. So, at any rate, let's say you go through this process. You talk to other people and show them what you think is different or what's unique, and you still make the decision to move forward. I recommend.
Nancy.
Oh, see you later, Steve.
Bye.
Here's just a couple of things that are going to come up the minute you talk to a patent attorney. All right, that they're going to start banging away on these terms that may or may not be obvious to you. Independent versus dependent claims. So your independent claim is the broadest and the first claim that you develop related to your patent application. Okay, and we should probably also talk about provisional versus PCT, and we'll get to that too, because that's a terminology as well. And so your dependent claims in your patent application are typically directly related to your parent or your independent claim. So your independent claim is your broadest, and then you start talking about methods, and you start talking about individual components and pieces that build into the larger whole, your first claim. Okay? You don't need to necessarily differentiate what those things are. Your patent attorney will do it for you. But it does help, excuse me, if you can, going through this due diligence process, you're going to see a lot of summaries and claims, and if you develop what you believe your claims are in that patent legalese, if you will. Your attorney will straighten those things out for you, but it at least gives him a better handle on your technology. If you start talking to a patent attorney and you have, let's say, figures or schematics of your invention, okay? You need to bring those with you. They're important. They're figures that they'll include in your claim, okay? If you have the chemical composition and you can prove that it's different than what's out there or what's obvious, you need to have that and you need to bring it. Patent attorneys typically have a science undergraduate degree, all right? So I recommend if you're going to pick a patent attorney, pick one that has expertise in the area and the field that you're focused in. So there are guys that specialize in mechanical, like physical properties. There are guys that specialize in chemistry. Don't pick the wrong kind of patent attorney because they will struggle to try and get their arms around what's novel about your product, okay? So you are in the driver's seat there. Don't just have, Uncle Carl take a look, okay? If you decide to move forward, it's worth picking somebody who has expertise in your field, okay? Method versus product, how do you make something versus what that thing actually is? You can, just so you know, you can include both method and product in a single patent application. There are times, however, if a patent reviewer comes back, he may say to you through the patent prosecution process, these things are separate and different, and you should actually separate these claims and file a separate patent application. That's prosecution. You can worry about that later. And then there's this big debate, and I don't know how much you guys know about patents. They go through patent reform every, 10 years or so. and I'm not sure if they're doing us a service or a disservice, but increasingly, US patent law is looking very much like international patent law. And one of the major changes in the United States was this, and this went into effect maybe a little more than a year ago. The United States used to be a first to invent country. So if you could prove through notebooks, emails, schematics with dates on them and things like that, that you had invented it first, you could invalidate somebody else's patent who filed after you. The rest of the world was first to file, all right? So this is encouraging a lot of people to file things really early using something called a provisional patent, and then revise their claims as well as their knowledge of a particular invention a year after that, because increasingly when you file is important. You have to get in first ahead of everyone else. Are there any questions on some of these terminology? Are you guys bored yet? Do you have, not bored? Okay. Does it make sense? This, the reason I'm asking is this is the first time I've delivered these slides, so if they're not helpful, you gotta tell me. So how do you make a go decision versus a no-go decision? These are kind of our laundry list that we use here at the commercialization. Commercial Ventures Intellectual Property Office here at the university on how we make decisions if we're going to file on something. So at the university here, faculty members, graduate students, postdocs who are inventing under federal grants, we have an obligation to review those inventions and to file on them if we do believe that they're novel. So we do a level of due diligence, and here are some of the things that are go decision, go indicators for us. I'm not going to bore you with why we do that, but we have an obligation here at the university under something called the Bayh-Dole Act that says if we get federal funding, we have to make every effort as an institution that receives federal funding to commercialize those technologies. Okay? And so we do that through a process called licensing and or startups. So I'm the startup person here at the university, but we have other people who specialize in large company licensing. So again, novel and non-obvious. So you can file a patent and say, hey, I noticed that 650,000 milligrams of calcium taken up once a month decreases your chances of osteoporosis. And that may be novel because nobody's ever had that much calcium on a monthly basis, extended release, but that would be considered obvious, right? Because there is already prior art saying calcium supplements help reduce osteoporosis, for instance, okay? And definitely that you've done some effort of prior art. Invention is enabled or additional development is planned. This is, do you have a prototype? Do you have something beyond this idea of a proof of concept? I think this will work. Have you tested it? Have you done any durability testing? Have you done, have you put it on a pool? Did you modify the design from concept to actual product? And do you have a plan moving forward with what's going to change in the next year or 2 years that is going to continue to flesh out the novelness of the technology or invention that you have? That's an indication to us that this just isn't a one-off eureka moment, but that you're actually going to move to develop and commercialize that technology, right? So that's an indication for us that's worth continuing to pursue. And again, I keep harping on this idea of commercial viability, but it's really, really important. You may have something that is novel, okay, and that is not obvious, but if you have no market or too small of a market, and yet you're going to spend, 20 or 60K, or if you want the entire world as your field, but you're only gonna sell 12 of them. It may not be worth patenting at the end of the day, okay? And there's ways to search for that and get that information. You could use the school's library, and they've got great information on this. But also, how are you gonna commercialize it? That's one reason I ask, you know, you have an invention, are you thinking startup, or are you thinking licensing? And if you're thinking licensing to a larger company, i.e. you don't wanna manufacture it yourself, you just invented it and you wanna give it to somebody else to make it and to distribute it and such, who might be interested? If you can't identify anybody who's really gonna be interested in your invention, you might wanna consider twice before you take on the expense and responsibility of maintaining a patent application, okay? So what do you guys think some of the no-go indicators are?
It's already out there.
Steve, yeah. So if you do a Google search and you find essentially the same thing, and you can buy it on Amazon, how about it? Because on top of it, you also have the potential to be infringing, do something called infringing on their patents, right? If you move forward with it, which means they could sue you because they have a patent on it and you don't. And they can force you to do what's called cease and desist. So you can't sell your product at the end of the day. That's litigation, patent litigation. And I'm not trying to scare you with patent litigation, but it does happen. And it happens a lot in pharmaceuticals, it happens a ton in software and mobile hardware, just so you guys know. So I don't think I need to. Here's the standards differ for various arts. So, you know, people go, hey, this is great, we're gonna use it in chemistry, but it has a medical application. That's not a good enough reason to file a patent application necessarily, okay? Because there's already somebody out there who's essentially invented it, you're just applying it in a new way, okay? Are there any questions here?
When can you do that?
What?
When can you do that? Like take a product that's available, or like a technology that's available, like use it until it doesn't have.
If it's not obvious and there's no prior art in the space, prior art's a big go, no-go decision. But if your application was not obvious, and you make a modification to that technology that enhances its use in a new field, your patent really focuses on that modification, not necessarily the original background patent. Okay?
Is there such thing as a modification patent?
No.
Okay. You just file just a general patent.
Yeah, but you focus on the novel piece or portion applied to the field of use. Okay. So, like a lot of pharmaceutical patents will do that. They'll say, well, we're using essentially the same drug, but we modified it for extended release and, you know, the mode of delivery, you know, the chains, you know, the chemical chains are slightly different in order to increase effectiveness. All right, so that's how they kind of work around that. But they also have, you know, I mean, patent lawyers sitting in their office, right? You know, and they do that intentionally to extend the life of their patent. Okay. Go ahead.
Say something like a bar of soap has already been invented, and so
Yeah.
it has prior knowledge or something like that, and you invent something that's a non-obvious change to it, would that be non-patentable?
No, if it's a non-obvious change, you can patent that. So,
In the
so
chemistry,
in your
production
situation,
and stuff like that, yeah.
I mean, we'd have to go through yours
Yeah,
in
yeah.
detail. You're not inventing the bar of soap.
Yes.
okay? And my guess is you're not inventing the chemical compound that's going into the soap that's creating heat, correct?
Hypothetically.
Hypothetically, you don't know.
I do know, yeah.
Oh, okay.
Trade secret.
Okay, so it's a known,
It's not a known reaction, but it's
it's not a known reaction to the chemical entity you're talking about.
Exactly.
Okay, which means something else has to happen to it in order to make the reaction occur.
Mm.
Is this reaction, so whatever you do to it, is it a process before you
Yes.
put it into the soap?
Yes.
Okay, so that process may be patentable.
Okay.
Does that answer your question?
That answers my question.
Without telling me too much?
Yeah.
Okay. I don't know the answer
All right,
exactly,
yeah.
but, because you'd have to do some prior art search.
Yeah.
But it could be the process, it could be however you modify that
Would
chemical.
I do a prior art search in the process or in the end result of the product?
Both,
Okay.
I would do both.
All right. On the end
So,
result.
so you can do, I recommend you try doing multiple searches based on multiple entry points. So if you have a process and you have a chemical and you have a method for modifying that chemical and or getting it into the soap and maintaining its properties,
So every little detail.
I would search on each of those
Okay.
things, because it sounds to me like you're able to really granularly break down your invention.
Mhm.
And so I would focus on each of the places that you think that your invention is unique.
Each of those places would be in the patent.
Yeah, so you basically would set up a keyword search,
Mhm.
through Google Patents, and I mean, nothing's ironclad,
Yeah.
right? You may do it one day and then you might slightly modify the order of the words the next day and get a completely different list to review. So nothing's completely ironclad, but that'll get you a good idea of what's been done before. So I recommend, start broad on your keywords, and then if you can break down different anticipated claims, search on those as
Okay.
well, okay? So patent prosecution timeline, so this is what we were talking with, I'm sorry, your name?
Joanne.
With Joanne, okay? So, you wanna file a provisional, if at all possible. And a provisional is essentially a patent that gives you a date stamp, but doesn't get reviewed by the US Patent and Trademark Office, okay? It gives you a whole nother year to refine your invention, okay? Based on what you learn in your patent prior art search, okay? Maybe you determine, okay, I think I've got general claims in this area and I need to have additional data in these 4 or 5 claims in my patent application, and I've got a full year to get those things, and I have a path forward on how I'm gonna get that information to make my patent application stronger. Because that's all supporting information that you can include in your patent application. So you have a full year, basically, where you get a date stamp, but you don't get a review, which means it doesn't really cost you anything with that initial application. After 12 months, you have to either abandon that date stamp, or you have the ability to do what's called convert to a PCT. And that's a full patent application that goes into the stack at the patent office, and they review it on a first come, first served basis, all right? Unless you expedite, which most people don't pay for expediting, let's say. Okay? And so then you enter this area of patent prosecution. And depending on how refined your claims are, and how much prior art there may be in a particular area that you filed under, this can be relatively quick, right? To really, really long, all right? So if you're doing anything in the area of software, for instance, first of all, 99 times out of 100, they've got it locked, somebody else has it locked up, some of your big usual players like Microsoft. And if you try to defend your patent, it's gonna take you forever, all right? It's gonna take you this 60 months, okay? If you are focused in your patent application, and it's an area with not a lot of prior art, and also not a lot of patent applications in that area, this process will go much faster. But you get a series of what are called office actions as the patent office reviews, and as you have the option to file in other places around the world. So I'm just talking about the United States right here, but you can file in Canada, you can file in Europe, and there is a strategy based on where you believe your markets are as to which additional countries you want to file in. And all of that starts really from this point on, after the PCT and when you start to do international. Go ahead.
Do you mean that, for example, Apple has a patent in every country they sell their products at?
Not necessarily, but they probably have patents in a lot of the countries that they sell in. So I wouldn't say they have every country. Some places it's kind of irrelevant. Yeah. Particularly if they have a small enough market in that area. So about 3 to 5 years, and if you're doing international, you're talking 5 to 7, and it does require some diligence. Yeah.
What if my patent takes, for example, 1 year, but in another country it takes 6 months, and the other guy can win actually with this invention?
I'm not sure I completely understand your question. See, what if the place that you originally filed?
I'm comparing to different countries. For example, if this process takes this much time, but in another country it takes, for example, less than a year, and the other guy can go to the other country and say, "This is my invention." This is
Yeah,
my patent."
no, that idea of this first to file versus first to invent and this standardization of patent law, international patent law, is actually increasingly preventing that. So your original date stamp in your original country of origin counts for most of the industrialized world. Okay, so if he then files somewhere else, so Europe, but you filed 6 months earlier in the United States, your patent application takes precedence. Yeah. And not every country falls into that category. So I don't know, maybe Uruguay. I can't say who's not in that. If you go to the Patent and Trademark Office, they'll tell you. You can look it up. But they have what's called reciprocal agreement. Okay. That's international law, and it's like I'm not an expert in that area.
Well, I have questions. Doing the prior art search as well as patent search, does the invention that within the application, does it show up in there or no?
So a PCT application does not show up until the 12-month date mark, okay? So even if you file a PCT directly, you have 1 year prior to publication. So there is a span where frankly you're just not gonna know based on your date stamp and the 1 year time frame if somebody else has beat you to the punch within that 12 months. Which is one reason it's worth going back and checking on a regular basis. So with our portfolio, anytime we get an office action, we do go back and we look to see if somebody's got a date earlier than ours. Because things do become published and decisions are made. So if we have something similar to a application that did not receive an issued patent or received an adverse or negative response from the Patent and Trademark Office, we know that our patent standing is shakier, right? And so we may make a decision, and you can make a decision at all of these office action points if you want to keep paying to try and get an issued patent, or if you've decided that it's not worth pursuing anymore. So you have a lot of off-ramps all the way through this process, and you can make those decisions incrementally. So, you know, when to file in Canada, you know, you have a time frame when you can start to file in Canada, all right? And you can make that decision at any time from that point forward, for instance. Okay. I can't remember what else I put in here. Oh, here's a little bit of cost. Time frame, you know, 5 to 10K if you're looking for a really solid provisional patent that will convert easily to PCT. Additional costs are based very much, like I said, on office actions. And if you get invalidated claims, for instance, that you want to defend, it costs more. If you get a request to invalidate a claim and you let it and you allow it to be removed from your patent application, obviously that doesn't cost you anything, right? So you need to make decisions based on that. And here's just a couple of the, you know, again, this is how we think about startups, because I thought a lot of you were interested in patents based on startups, but I don't need to belabor this. You know, again, you've got this novel, unique, and compelling idea, but you've also got, you know, a clear idea of exit paths, et cetera. So your IP isn't the only thing that you should be riding on, but also potential partners and ability to finance and some of these other things, but I won't belabor this.
Can I go back to the other slide? When you said 5 to 10 for provisional, does that include lawyers?
Yes.
Is that fees? Okay.
No. The fee is cheap. This is really, you know, what are you gonna spend on lawyers as well as application fees.
What's the row? The last thing says 3,200K patent grant in each country in the row.
That's the international standard.
Okay.
I apologize. I don't know off the top of my head what it stands for.
It's like the UN, but it's called the row.
Yeah.
Is there a way to get a provisional application or patent without using attorneys?
Yes. I mean, you can go up online. You have to, there are online systems where you essentially do all your work, develop all your claims independently, and it's cheaper. It's not dramatically cheaper because, you know, you still have to have patent agent status in order to finally file it, so you have a filing fee charge associated
That's what
with those.
that's what I was wondering.
Yeah,
Okay.
so there's a filing fee at the Patent and Trademark Office, but if you're using one of those like online systems or like a do-it-yourself patent system, you still have to submit to somebody else who then basically uses their
So the
accreditation
individual
to file on
cannot
your behalf.
actually file.
No,
that
you
patent.
can't just be like, hey, I'm Nancy, and here's my claims. A patent agent has to file.
I didn't know
for you.
like if they let a provisional patent do that versus
No.
obviously a full patent, they wouldn't. Right.
No.
Well, that's too bad.
Well, because theoretically what they've decided is a patent agent has a level of due diligence that they do and experience.
And they don't get so
based
many.
on- Yeah, and it cuts down on who's applying and the, it somewhat limits the quality dispersion, let's call it that.
Makes sense.
If anybody could just send an email and be like, hey, here's my $50, consider this. The Patent and Trademark Office is already pretty inundated, which is one reason it takes so dreadfully long to get through the process. They don't have enough reviewers, they just don't. So, you know, hey, for those of you who are engineers, et cetera, consider the Patent and Trademark Office. Pays pretty good, and you can see all the latest inventions. So I don't know if there are additional questions or if it's worth walking through Google Patents. I think that may be overkill. I mean, you guys know how to use Google, it's pretty much the same thing. But I can show you kind of what pops up and what it looks like. You know, there's a whole list of claims, there's a summary, there's a broad statement. Is it worth going through or?
Yeah.
Yeah. So there you go, Google Zoom comes right
Yeah.
up, right?
Yeah.
Okay. So do we want to do a real world one? Who wants to give me something that I can put in here?
Heated soap.
Heated soap.
So your soap heats up when it hits cold water.
What else can you tell me about the soap?
Currently, it's only in bar form.
Chemical reaction?
Yeah, exothermic reaction.
This is if you're looking for something in someone specific, but we can do a general search here and see. So you have metal soaps, you have sperm oil now, that's one we really want to read. But see, look at the age here, so this is pulling everything. So look at some of these folks, these were filed and issued in the 50s, in the 40s, okay? And frankly, you know, the term of that patent has expired, but at the same time, it's also pretty irrelevant. It's a metal soap and a sperm oil soap, right? But
Good
here's the
question.
process for manufacturing soap, yep.
If probably the process, what they have down there is a lot like my process, except little tweaks here and there, different differences, big differences in certain parts. But definitely there are parts of the manufacturing that are same to regular soap.
Mm-hmm.
What would happen with that? If there's like, say, the beginning part is
A process you look at holistically. So, I mean, I don't know, the fact that you heat it to a certain temperature is part of the process, but they're looking at the whole process.
okay.
And if that's different, if you do something differently that means that the soap heats effectively to a certain temperature,
Yep.
that's relevant.
Okay.
Okay. But yeah, I mean, I don't know, the fact that you stir it counterclockwise or something like that, no, it's still part of the process, and but you're looking at the whole process.
All right.
Okay? Not just that individual action in the process. Okay, so, speaking of process of manufacturing soap, okay, this is a bad one for getting an idea of claims. Let's go something a little more current. In the 80s, oh my goodness, here's 2005, method for producing calcium soaps for animal feeds. You should see something pretty clean here, yeah, okay. So you have a general description, you have a state of the art, all right? So they're talking about methods. This is a method patent for production. So this gives you a nice kind of summary on the left-hand side, and it references prior art, okay? So it's saying, look, I know that these things about developing soap already exist, okay? And so you address those up front. And then over here to the right, you'll see that there are claims, right? Number one is always your broadest claim. And then you typically have several supporting claims. So, you know, these are your dependent claims. And then you have another major claim in 8 with your supporting claims underneath that, okay? But, you know, at the bottom. So clearly, they've had some publications related to this patent application. And the examiner has cited additional patents that he believes are relevant to this claim, okay? Now, he may decide that this Great Britain one supersedes this patent, and he's notified that inventor that he believes that, and they can either continue to make that claim, to defend that claim, or they can drop that individual claim, okay? Let's see, up at the top here, you may find this kind of interesting. The inventors are not necessarily the applicant. So in the case of UMass Lowell, the inventor would be the faculty member, but the applicant is University of Massachusetts Lowell. All right, so we defend our own patents. You'll see this in large companies. If you have a company, the company's the applicant, and you're the inventor. All right. Are there any other questions? So the PCT basically gets you on the international track. I don't know if your patent attorney explained that to you when you converted. So now you'll get notification that you've converted in international in the US, and then at certain times moving forward, they'll notify you that if you're interested in filing in Canada or Great Britain or EU, that application is typically due. They typically give you notice 6 months before it's due. But your filing date in the US takes precedence to the filings, the international filings that you do after.
Actually, mine is a design patent.
All right. So are there questions? Are you more knowledgeable or less knowledgeable than before you came here?
More.
Okay. All right.
Places to start anyway.
Yeah. For students, actually, I did fail to highlight this for you guys. So John and Aaron did mention that University of Massachusetts Lowell, because how many students do we have? It's about a half and a half crowd. Students, come on guys, there you go. So this may or, this is probably, unfortunately it's not relevant for the E for All folks, but the university is working on a student IP policy, but if you invent something on your own independently of, even within your coursework, so if you did it as a capstone project or something like that, that potential intellectual property is yours. It's not the university's. You can choose to do with it what you want, and we want you to choose to do with it what you want. There are some cases, and in John and Aaron's situation, they didn't have money to file. They had a huge amount of support from the university in the use of equipment and tools in order to develop their prototype, etc., that they approached us and said, hey, can you help us out here? And so we developed this. This is a draft. It's not set in stone, where we want students to understand that we're happy to talk to you about your IP. We're happy to give you some advice. If you don't come to me with a list of 350 other pending patents that you want me to look at, I'm not going to do that for you. But if you come to me and say, look, I think I have something novel and this is what I think I have, we can do some level of informal discussion and advice. We're more than happy if we get through that process and think you've got something unique that we're willing to help defend, to ask you to go through something called the disclosure process here at the university, and then we'll do our own independent due diligence evaluation on that. And we may or may not choose to do a provisional filing. We don't convert to PCT on the outset without some movement from you in regards to how you're going to commercialize that product, okay? But this is the process. We ask you to assign rights so that we can defend your patent for you on your behalf. And then most people who are interested in doing that, in John and Aaron's case, they wanted to do a startup, they asked that they reserve the option right with the university. for that IP. So if they continue to pursue a startup, they're gonna option that technology back that the university is defending for them currently. Yeah.
Say you might have someone that knows a little bit about your invention. Is there any way to prevent them from kind of telling anybody?
Mm-mm.
No?
Not unless you had them sign a CDA,
What is that?
confidentiality agreement. And you can prove that they're in clear violation of that CDA.
I mean, they haven't violated anything, but I'm just saying, someone might know, how would one get a CDA or create a CDA?
You can search them online.
Okay.
I mean, they're kind of a standard blanket document. If you contact me and say, hey, what's the university template look like, I can share it. In
Alright.
fact, I think there's a CDA even on the UMass Lowell website that you can
Alright.
just download.
So you just hypothetically print this out and say, hey, sign this.
Well, I think you should inform them
Well, obviously, yeah.
of why you're asking them to sign this.
Yeah.
If it's somebody who's a potential partner with you,
Hmm.
a founder or something along
Yeah.
those lines, if you're talking to investors never sign CDAs.
Mhm.
Because they use some of those sit-down meetings in order to gain more information in an area that they're already interested in investing in. I think most people do use CDAs too freely, if you want my personal opinion.
Mhm.
And I think when you walk into any situation or any relationship and say, basically with a CDA, I don't trust you,
Hmm.
but I want your information, or I want your feedback and some of these other things, you automatically put the opportunity to learn about your technology and get feedback based
Yeah.
on your technology at a disadvantage. People won't be as free with you in the fact that you believe
Yeah.
that they're gonna snooker you to a certain
Yeah.
extent. The reality is, chances are what this person knows, unless they've been working with you on the chemical compounds or some of these other things, isn't material enough to actually undermine what you believe your opportunity is.
Okay.
Like I said, you start talking about, chains and processes and chemical compounds and what you've tried and what you've eliminated and some of these other things. Those things are that you should consider keeping confidential, but my guess is most of the conversations that you have, because you're having them in an individual, a small piece of the whole project, probably really aren't worth trying to tie up with a CDA. Suddenly you'll have 150 of them, and you really, it's hard to reinforce. I'm spouting my own personal opinion on these, by the way. This is not the university position or anything
right.
like that. But it's really hard to prove if a company down the street pops up with almost the exact same idea that you can connect it to the guy that you talked to. And trying to litigate that is pretty challenging unless, and pretty expensive. So
Yeah.
at the end of the day,
It's not worth
the
it.
CDA is probably not worth it,
Okay.
particularly if you're not gonna prosecute it.
Mhm.
Then don't bother.